So I am Gauthier Chassin. I am a lawyer at the INSERM in France, the French Institute of Health and Medical Research. And in this session, we will interest us to the new General Data Protection Regulation of the European Union, the EU GDPR, dealing with the protection of natural persons with regard to the processing of personal data and the free movement of such data. The GDPR has been adopted in 2016 and will enter into force on the 25 May 2018, thus repealing the previous EU directive of 1995. And today we will in particular address the provisions that will impact the research activities based on personal data and that will need to be considered in the activities of infrastructures such as phenomenal for ensuring compliance. So for doing so, we will successively tackle the essential legal notions of the GDPR that will be helpful to navigate through the regulation. We will tackle the new approach of the GDPR, the main evolutions regarding data controllers and processors obligations, and the main evolutions regarding individual rights for personal sensitive data processing, and we'll have a view on the sanctions. Essential legal notions in the GDPR. The entire regulation is about personal data, meaning any information directly or indirectly relating to an identified or identifiable natural person, the data subject. This definition includes data in paper or digital formats, text, pictures, print, identifiers made of numbers, and includes coded and encrypted data as indirectly identifiable data, now named pseudonymized data. The definition excludes data that are not or cannot anymore be related to an identifiable natural person, the so-called anonymous or anonymized data. The capacity of the data not to be linked to an individual identifiable data subject must be tested in specific contexts in order to prove validity. This is very important, and for helping operators to construct valid anonymization techniques, you have European guidelines adopted by the Article 29 Data Protection Working Party that are available online. Among personal data, we find a special category of personal data, the so-called sensitive personal data, whose processing is particularly regulated due to the risks it entails regarding the rights and freedoms of data subjects. Personal health data, genetic and biometric data are included in this category. The processing of such data is forbidden by principle and accompanied by limited exceptions, among which we find the necessary processing for the purposes of preventive, occupational medicines, for healthcare provisions, health services administration, for public health protection, and processing necessary for archiving purposes in the public interest, scientific or historical research purposes, or statistical purposes. When you are in this case, you can validly pretend to be exempted from the initial prohibition of processing of such data. Interestingly, the GDPR now provides clear definitions of personal health data, genetic and biometric data, all being included in the sensitive personal data category. To what concerns the notion of health data in particular, it is interesting to note that it should include all data pertaining to the health status of a data subject which reveal information relating to the past, current, or future physical or mental health status of the data subject. This includes information about the natural person collected in the course of the registration for or the provision of healthcare services, and other information collected from other sources, from a physician or other health professional, from an hospital, from a medical device, or an in vitro diagnostic test. This covers, for example, information collected from the testing or examination of a body part or bodily substance, including from genetic data and biological samples analysis. It relates to any information on a disease, disability, disease risk, medical history, clinical treatment, or on the physiological state of the data subject. These definitions are very important for lawyers, but also for operators, as they base a mutual understanding of the scope of the regulation. The GDPR also concerns processing operation, personal data processing operation, meaning any operation or set of operations which are performed on personal data or sets of personal data, whether or not by automated means, for an identified purpose. The definition of the purpose is very important because all the legal regime will be attached to such a purpose. The notion of processing covers any kind of operation from the initial collection of the data to their secured destruction. It also covers activities from public or private entities, and it is excluding some special processing governed by other rules, like the personal data processing performed in the context of police investigation, for example, or criminal investigation. The regulation applies to several subjects. The first one is the data subject, that is identified or identifiable natural person to whom the personal data processed relate. In our context, it will be the research participant. It is the addressee of the rights. We have the data controller, that is a natural or legal person, public authority, agency, or other body which alone or jointly with others determines the purposes and the means of the processing of personal data. In our context, it will be the research promoter or the principal investigator. When there are several controllers, the relationships between them must be formalized into a contract. We have also the processor, the data processor, that is the natural legal person, the public authority, agency, or other body which processes personal data on behalf of the controller. In our context, it will be the investigator. The processor and the controller are both addresses of the obligations fixed by the regulation. We have now another legal subject that appeared with the regulation, that is the data protection officer. The data protection officer is a referee for data protection issues acting with the controller and processors. It is part of the new governance practices initiated by the GDPR, which are intended to reduce the risks of contractual, administrative, or judicial litigation. And then the regulation applies to supervisory authority, that are the national data protection authorities as independent public authority established by member states, and that ensure monitoring of personal data processing operations. They register and authorize some of them. They issue recommendations or advices and receive complaints from data subjects. In the context of cross-border processing involving several member states, a new notion appeared of leading supervisory authority. It is the authorities that will coordinate the works with other authorities. Let's have a look now to the new approach adopted by the GDPR. The GDPR keeps its goal-oriented approach as a legacy from the previous directive of 1995, but operates updates of the rules representing a paradigm shift based on the potential risk of the processing regarding data subjects and freedoms. This will be rooted to a risk analysis and linked to graduated constraints according to the risk. It is based on accountability of the actors of the processing operations. So we have updated control mechanisms, mandatory record of processing, self-regulation possibilities, certification possibilities, and also reinforced sanctions. We'll come back on these points later on. The new approach is also based on transparency of activities as regards to the data subjects whose autonomy and rights have been reinforced, and on updated general data protection principles, the principles of lawfulness, fairness of processing, the purpose limitation principle, data minimization, data accuracy, storage limitation, including, as in the previous directive, an exception for scientific research, where it is possible to keep in an identifiable form the data for a longer period than the one initially necessary to fulfill a purpose, because it is necessary for scientific research. The principle of data integrity and confidentiality, and the principle of accountability. All these principles have been reinstated, but now some updates. And also, a quite new thing in the regulation is the consideration of recognized ethical standards of regulated professions. What is particularly important in our case, because we have a lot of recommendation, ethical guidelines at European and international level, but also at national level, that must be considered regarding data processing. I mentioned here the Council of Europe recommendation, of course the World Medical Association declaration, and the OECD guidelines also. Another new is that the regulation intends to have a long-term approach. The rules fixed by the GDPR aims to ensure an efficient and sustainable protection in an evolving technological environment. Therefore, the GDPR covers the entire data life cycle of the data and imposes to consider and integrate data protection principles and rules from the early development stages of a processing operation or of a personal data processing device, as well as the protection by default of the data, meaning without any human action, that will last for the entire duration of the processing and data life cycle. This approach should be translated through the setting up of organizational and technical measures intended to ensure compliance with the GDPR in a particular context. The GDPR also reinforces liability chain for professionals involved, including in an international data transfer situation with non-EU countries where contractual guarantees have been reinforced, and improves the autonomy of data subjects in the management of their data through several updates of their rights. Besides these advances, something also quite interesting to look at is the scope of the regulation that is extraterritorial. Indeed, the regulations still apply to activities of an establishment of a controller or a processor in the EU, regardless of whether the processing takes place in the EU or not. But it is now also applying to the controller or processor that is not established in the EU, where the activities are related to the referring of goods or services, irrespective of whether a payment of the data subject is required, or to the monitoring of the behavior of European citizens as far as their behavior takes place within the EU. It applies also to controllers not established in the EU, but in a place where member states law applies by virtue of a public international law. So you can see here that with the regulation, the scope of the law goes beyond the European borders, what can create complexities, but it appeared as being the only solution for ensuring an efficient protection of the data, considering the intense movement and international feature of this movement of the data. So besides these advances, the GDPR also brings some new obligations for data controllers and processors, some updates to existing rights, and elaborates some new rights for the data subjects. And I propose to you to come back on each one. First, the new obligation of data controllers and processors. Special obligations arise from the regulation in the context of big data processing, taking into account the nature, the scope, and the context and purpose of the processing. The use of new or innovative technologies, such as whole genome sequencing, for example. The nature of the data, in our case, it is sensitive data, health data, or genomic data. The large scale of the processing, what constitutes the big data, considering the number of data subjects concerned, the volume of the data concerned, the duration of the processing activities, and the geographical extent of the processing activities. We also consider here the vulnerability of the data subjects. Sometimes it is concerning children or elders, so people with reduced abilities to understand, but also with reduced legal capacities. And the likeliness of the processing to result in high risk for data subjects' rights and freedoms. So considering this, we can see that for the phenomenal infrastructure, two new special obligations will need to be considered. In particular, the first one is regarding the data protection officer, and the second one is regarding the data protection impact assessment. To what concerns the data protection officer, the designation will be mandatory in such a context. The DPO is a new important and independent actor to associate from the earliest stage in all the issues related to data protection. He has to inform and advise the controller or the processor and the employees who carried out processing of their obligation, to monitor compliance of policies, contracts, including the assignment of responsibilities, of an awareness raising and training of staff involved, to advise in the performance of the data protection impact assessment, to cooperate with the supervisory authority, and to maintain updated records of data processing operations. The DPO can be the contact point for the data subject's requests. It is not mandatory, but it is a possibility. It can be an employee or an external service provider subject to relevant secrecy and confidentiality duties. There can be one or several DPOs given the size and structure of the organizations, but the important thing is that he has dedicated resources that are necessary for his work. So in order to be efficient, available, and responsive. Some European guidelines have been issued also by the Article 29 Data Protection Working Party about the data protection officer, describing its responsibilities, its role, etc. So feel free to consult them. Regarding the data protection impact assessment, this one will also be mandatory prior to the processing, and it shall at minima provide a description of the envisaged processing operation and the purpose of the processing, an assessment of the necessity and proportionality of the processing regarding the purposes, an assessment of the risks to the rights and freedoms of a data subject, and the measures envisaged to address the risks and to demonstrate compliance with the GDPR. In such an exercise, the views from data subjects or their representatives shall be thought, notably on the proposed means of the processing, where appropriate. And in our context, it could be appropriate to consult them, or at least patient association or other representative bodies. The DPIA report will be recorded by the DPO, and if residual risks remain important and cannot be coped by the controller, there will be a need here to consult the national authority, the supervisory authority, for authorizing the processing. Member states shall publish lists of processing for which DPIA is required. Presently in France, it does not be the case, so I don't know what is the situation in UK, but things will evolve in the coming month. Some guidelines and tools are already available. So at national level, I know that in UK, the ICO has already issued some specific guidelines regarding DPIA. The CNIL also in France did the same, and also provided a software to help operators to practice the DPIA. And you also have here European guidelines from Article 29, Data Protection Working Party. Another new obligation that is general at that time is about the notification of data breach. This new obligation is related to the obligation made to controllers to maintain security of processing. Indeed, when implementing technical and organizational measures to ensure a level of security that is appropriate to the risks, consideration should be given, amongst other things, to the ability to ensure the ongoing confidentiality, integrity, availability, and resilience of processing systems and services, and to the ability to restore the availability and access to personal data in a timely manner in the event of a physical or technical incident. So the mandatory notification is prolonging these obligations that was pre-existing in the previous directive, but that is now completed by this notification system. According to the regulation, a personal data breach is a breach of security leading to the accidental or unlawful destruction, loss, alteration, unauthorized disclosure of or access to personal data transmitted, stored, or otherwise processed. So, in a case of a data breach notification, how to proceed? The first thing is to consider the entire situation from the beginning. So as soon as you have a suspicion of a personal data breach, you should immediately investigate it. When you have a confirmation of a breach, an immediate notification of the data controller shall be triggered. As soon as the controller is aware of the breach, the data protection officer must be involved, and a 62 hours delay starts for notifying the supervisory authority. One of the first things is to qualify the breach. It can be a confidentiality breach where there is a disclosure of or an access to personal data. It can be an integrity breach where there is an alteration of personal data, a modification of their content, nature. An availability breach where there is a loss of access to or a destruction of the personal data. For example, in the case of a securely encrypted data, the decryption key has been lost. This will be qualified as an availability breach. The loss of data availability can be temporary or permanent. In the event that the controller cannot restore access to the data, for example from a backup, then this is regarding as a permanent loss of availability. Then you have to go deeper into the analysis of the breach, so performing, let's say, technical analysis of the causes of the pathway and impact of or risk of impact of the breach regarding the ongoing processing, but also regarding the data subject rights. Here, in such analysis, the collaboration of all the actors is very important. Furthermore, because we have to act, promptly. So the controller needs the processors to collaborate into the investigation and analysis in order to bring very fine data about the causes and consequences of the breach. At the same time, so the controller and the processor must act to contain and recover the breach. So he has to manage in parallel two things: the notification of the breach and all the process that is behind, and concrete action to contain or recover the breach. So in case, so then we have a dual system of notification. So first, we mentioned the notification to the supervisory authority. This is mandatory where the breach is likely to result in risk to the rights and freedom of data subjects, and in our context it will be almost systematic. The notification does not have to be done in one time. You can do it step by step, where it is necessary to further investigate the circumstances of the breach. So you can perform an initial notification, communicating, for example, on the nature of the breach, and providing some broad data but not fine data, and then provide complementary information through supplementary notifications. In certain cases, only in certain cases, notification of the breach to data subjects will be rendered mandatory. This is the case when the breach is likely to result in high risks of damage or damages the rights and freedoms of data subjects. There are limited exemptions here, such as, for example, for data rendered unintelligible, provided that the key has not been lost with the data. And in such a case, the breach is unlikely to have negative consequences for individuals where efficient backup are in place. Where no backup is in place, it could have implications for the data subjects, but it would also qualify as an availability breach. The communication of the data subject, when it is required, can be done individually or through general communication means where it is impossible to do otherwise, and this has to be justified with the DPO and with the authority. And whenever possible, the communication shall include directives for the individual to palliate to the breach and avoid new similar ones to occur. So the notifications content is fixed at minima by the GDPR. You have seen that the 72 hours delay is quite short, so it is important to plan a specific procedure to address the breaches, and any delay in the process must be justified to the authority. After the notification, during and after the notification, you will have the opportunity to establish and implement a post-breach plan, and this will necessitate also a follow-up through audits, but you have also European guidelines here from the Article 29 Data Protection Working Parties that will give you more details about the notification processes. Here is a picture that I will not describe to you because it is of poor quality, but it is important to have a view on it. It is representing an optimal GDPR data breach notification timeline. So you can see again that time is crucial, and any suspicion of breach must be taken seriously. Let's turn our attention now to the main evolutions regarding individual rights, regarding personal sensitive data processing. So the first statement to do is that the GDPR does not achieve perfect harmonization of the rules for scientific research. This is explained by the fact that the European Union does not have full competencies to harmonize the field. So national law prevails here. Member States' law should provide for appropriate safeguards in accordance with the GDPR for the rights and freedoms of the data subjects, such as, for example, measures to ensure the respect of data minimization principle, and in particular through pseudonymization techniques, where the research purposes can be fulfilled in that manner, or a requirement, if it is deemed necessary, to use anonymous or anonymized data where feasible. Member States are also authorized to provide specifications and derogations with regard to most of the individual rights, so meaning right to information, to rectification of the data, to erasure, to be forgotten, to restrict the processing, to the portability of the data, to object processing, when processing personal data for archiving purposes in the public interest or for research purposes justifies. So let's imagine that we are in a situation where most of these rights apply, and we will focus now on the updates brought by the regulation on the most important rights mentioned here. So the GDPR first updates the right to information and transparency. The right to information is an essential right conditioning the exercise of the other data subjects' rights, such as the right to oppose, for example, or the right to access or to validly consent to a processing. The information is to be provided by the data controller, by written or by other means, including where appropriate by electronic means, at the time of the data collection and before reusing the data. The information must be provided in a concise, transparent, intelligible, and easily accessible form, using clear and plain language, in particular when it is addressed to a child or other vulnerable people. Now, the GDPR distinguishes between two different situations for which it provides a list of items to inform, namely the situation where data are collected from the data subject, so directly from the data subject, via the use of questionnaires, for example, or through the use of electronic devices, such as applications, for example, recovering heartbeats, for example. And the situation where the data are not collected from the data subject, such as the situation in which the data are collected through an existing database, for example. According to these lists, from a general standpoint, the data subject must be informed about the identity and the contact details of the controller, and where applicable, of the controller's representative, about the contact detail of the data protection officer, about the purposes, of course, of the processing, about the categories of personal data concerned, about the recipients or categories of recipients of the personal data, about the controller's intention to transfer personal data to a recipient in a third country or to an international organization, and the existence or absence of an adequacy decision concerning this transfer, or reference to appropriate safeguards in place, such as contracts, data transfer agreements, things like this, and the means to provide a copy of them where they have been made available. So, in addition to this information, the controller shall provide to the data subject with any supplementary information necessary to ensure fair and transparent processing. This is involving new items, such as the storage duration, the data subject's rights, the source of the data, and the existence of automated decision-making based on the processed data, for example. So GDPR plans also some exceptions to the right to information. This concerns situations where the data subject already possesses the information, of course, situations where the recording or disclosure of the data is expressly laid down by law, or where the provision of information to the data subject proves to be impossible or would involve a disproportionate effort. And this is particularly important in our case because in the research field we have very often databases, very large databases dealing with thousands of individual subjects and related data, of course, and it is disproportionate or often impossible to communicate directly, individually with the individuals. So in such a case, the number of data subjects, the age of the data, and any appropriate safeguards adopted should be taken into consideration to validate the exception or not. And in most countries, exception to this right and others will require prior research ethics committees approval and information of the supervisory authority. The consent notion has also been updated. So consent is any freely given, specific, informed, and unambiguous indication of the data subject's wishes by which he or she, by a statement or by a clear affirmative action, signifies agreement to the processing of personal data relating to him or her. Consent still be one of the legitimate ground for personal sensitive data processing, among others. So this is very important to recall. So member states' laws can plan other ways of accessing and processing personal sensitive data on the basis of opt-out mechanisms, for example, the non-opposition mechanisms that will be perfectly valid and perfectly respectful of personal data protection. But consent should be the privileged mean to process such sensitive data. With the regulation, it is important to see that the consent notion is only considered as an opt-in mechanism. So as soon as we have to deal with opt-out mechanisms, it is not considered as consent under the GDPR. What does not mean, again, that it is illegal, unlawful. The consent for, and this is important for research purposes, can be given for one or several purposes. So this is opening granularity possibilities with choices and options for the data subjects. This is quite useful to allow, let's say, multi-layered consent or even broad consent mechanisms, provided that it is respecting the other rights and the ethical guidelines applicable to the situation. But it is not invalidating broad consent approaches, what is interesting for us. And in research, in particular, data subjects should be allowed to give their consent to certain areas of research or parts of research projects to the extent allowed by the intended purpose and ethical standards applicable. Now, the GDPR recognize e-consent mechanisms and oral consent possibilities, where this is allowed by national laws. The condition for a valid consent is that the consent be distinguished or distinguishable from any other engagement of the person. So it should be clearly identified that this is concerning data protection. And the GDPR open right to consent withdrawal. It was not the case previously. So consent withdrawals shall be ensured and made as easy to give than the consent. So it's important to think about it and to think also about the consequences of a withdrawal for the data. Now, a little point on the reuse of personal data for scientific research. So, in any case, the processing of personal data for purposes other than those for which the personal data were initially collected must meet the general data protection principles, and in particular the principle of lawfulness and data minimization. Such a reuse should be allowed only where the processing is compatible with the purposes for which the personal data were initially collected. And in such a case, no separated legal basis from that which allowed the collection of the personal data, the initial collection, is required. Further processing of personal data for scientific research purposes is to be carried out after an assessment by the controller of the feasibility to fulfill those research purposes by using only anonymous or anonymized data, and provided that appropriate safeguard exists, such as pseudonymization. So in such a situation of reuses, it is important to check the legal basis for the initial processing. where it is based on an EU or national law, which constitutes a necessary and proportionate measure in a democratic society to safeguard, in particular, important objectives of general public interest, the controller should be allowed to further process the personal data irrespective of the compatibility of the purposes, because this is by law. Where the initial processing is based on consent, you have to check the initial information provided and the scope of the consent. In case of doubt about the compatibility of the initial informed consent with the characteristics of the further use, it is recommended to perform a purpose compatibility test that is presented into recital 50 of the regulation. According to this test, in order to ascertain whether a purpose of further processing is compatible with the purpose for which the personal data are initially collected, the controller should take into account, inter alia, any link between those purposes and the purposes of the intended further processing, the context in which the personal data have been collected, in particular, the reasonable expectations of the data subjects based on their relationships with the controller as to their further use. So this is a kind of non-surprise clause. The nature of the personal data and the consequences of the intended further processing for the data subjects, as well as the existence of appropriate safeguards in both the original and intended further processing operations. Where none of these elements evolved in a way that will create new or additional risks for the data subjects, the data can be further processed on the same legal basis than for the initial processing. Otherwise, the controller will need to base the further processing on a new legal basis and practice, for example, a reconsent process or obtain a derogation from a competent authority or research ethics committee. Other news, the regulation is fixing some new rights. First one is the right to be forgotten, droit au déréférencement in French. It has been created by a famous judgment from the European Court of Justice, Google against Spain, in 2013. This right prolongs the right to erasure in a digital environment. Nevertheless, it could be differentiated from the right to erasure, as the right to be forgotten only imposes to erase the data used by search engines for formulating results after requests. This right to differencing can be exercised separately from the right to erasure and does not necessarily include the erasure of the source data, which might continue to exist. The right to erasure and to be forgotten have the same conditions to be exercised. The personal data shall be no longer necessary in relation to the purposes for which they were collected or otherwise processed, or the data subject withdraws consent on which the processing is based and there is no other legal ground for the processing, or the data subject objects to the processing and there are no overriding legitimate grounds for the processing, or the personal data have been unlawfully processed. They also have the same limitations where the storage of the data at stake is necessary for public health purposes, for example, but also for research purposes, for the exercise of the freedom of expression, or where the storage is required by law, or where it exists reasons to restrict the processing instead of erasing the data. The GDPR also creates a new right that is a right to data portability. This right prolongs the right of access to the data that was pre-existing under the directive. But with this new data portability right, the data subject has the right first to receive the personal data concerning him or her, which he or she has provided to a controller in a structured commonly used and machine-readable format. Secondly, with this right, the data subject can ask for the transmission of those data to another controller without hindrance from the controller to which the personal data have been provided. The conditions to exercise these rights are dual. First, the processing must be carried out by automated means. Secondly, the data subject provided the data on the basis of consent or for executing a contract. The notion of provided by the data subject, so this right only apply when the data have been provided by the data subject, is a little bit more elaborated in the European guidelines from Article 29 Data Protection Working Party, that says that this covers data actively and knowingly provided by the data subjects. For example, when they will fill in a questionnaire or participate to interviews, for example. But it is also covering observed data provided by the data subject by virtue of the use of a service or of a device. For example, it will be the location data collected when using a smartphone, but also other raw data such as the heartbeat tracked by a wearable device, for example. In such cases, the individual will have a data portability right. In contrast, portability does not mandatorily apply to inferred data and derived data which are created by the data controller on the basis of the data provided by the data subject. So it is quite difficult and important also to be able to disentangle these complexities to know if the data can be eligible for erasure and portability. The GDPR also plans derogations possibilities to these two new rights. So member states can derogate by national law to these rights, but also the EU, where the data are necessarily processed for a task carried out in the public interest. And in these circumstances, some researchers could not qualify, even if most will pursue a public interest. And insofar as such rights are likely to render impossible or seriously impair the achievement of the specific research purposes, and that such derogations are necessary for the fulfillment of research purposes. In such a context, we will need to consider ethical standards and related impetus. For example, in the context of data portability, for example, as we have seen, portability was not applicable to derived or inferred personal data. But in the research context, in particular in genomic research, we find situations where it is ethically requested to provide back inferred data to the individuals, such as in the case of the discovery of actionable incidental findings. This is not planned in the GDPR. It goes beyond to the competencies of the European Union to legislate, but it relies on many ethical standards. So we will need also to consider and to coordinate the rules in practice. The GDPR also updates the right to lodge a complaint, so it will be possible to lodge a complaint with the national authority of your country, regardless of the location of the concerned data controller or processor. And this is a good news. It is allowing now class action for better protection of data subjects, very often alone in front of, let's say, most powerful operators. The GDPR finally reinforces sanctions, and infringement can be costly, as you would say. So the sanctions can be pronunciated after complaints from data subjects, after inquiry or audits also. The data controller and processor's co-liability is reinforced with the regulation, and 3 types of sanctions can be planned. The first one are public warnings from supervisory authorities. So it is aiming at it is aiming the reputation finally of the operator in a first intention. And then there are administrative sanctions that have been really reinforced, and that can go up to 20 million euros for public organizations, and up to 4% of the total worldwide annual turnover for private entities. What is huge when we consider transnational organizations such as the GAFAM, but also in our domain, private entities such as Privers, EBI, of course, etc., etc. Other penal sanctions can be also pronunciated, but they are regulated by member states law. So to conclude on this overview, we can say that the GDPR brings some innovations in the conception of personal data protection, characterizing the European privacy culture. Its entry into force in May will clearly be an historical moment. And while the research sector is less impacted than others due to the prominent competency of member states to legislate in the field, some news will need to be considered and implemented into the research projects and infrastructures. Some tools are already available to facilitate compliance, so keep calm and prepare by using a step-by-step approach. It is feasible and highly desirable, even without considering the strong sanctions, Some issues remain to be solved and will need to be dealt at national level or from an ethical point of view, as we have seen. Finally, it is useful to mention that the current coordinated initiative from European biomedical research infrastructures such as BBMRI, ERIC, Elixir, Eatris, aiming to set up a European Code of Conduct for personal data processing in health research that, once achieved, will serve to facilitate both compliance and sharing of personal data for health sciences purposes. So work are in progress, and things will really advance quickly in the coming month. So thank you very much for your attention, and I will be ready to answer to your question as far as I can. Thank you.